Chief Justice, member of the Judiciary, colleagues and friends, I'm delighted to welcome back Justice Edwin Cameron, formerly of South Africa's highest constitutional court and Chancellor of Stellenbosch University, for his third visit with FLAC, and to provide a special guest lecture entitled Social and Economic Rights, What Can Judges Do? We apologise for the late start, but there was problems with Dublin traffic. Justice Cameron gave the Dave Ellis Memorial Lecture in 2016 and launched the FLAC report, Lydia Foy's Struggle for Transgender Rights, in 2018. In these very grim times, when I heard Edwin was visiting, I couldn't pass up the opportunity to once again exploit his great generosity to motivate and inspire. The fact that 200 people have registered at relatively short notice is a testament to how eloquent and inspiring he is. And I'm just really sorry that it has to be by Zoom. It would be so much nicer to be in person. So much has happened since his last visit. COVID has highlighted and exacerbated the inequalities that exist, as we see in the huge, almost overwhelming demand for FLAC services. The work of our independent law centre, the Roma Clinic and the dedicated Traveller Service is primarily about the pursuit of social and economic rights, which can be difficult, exhausting, and more often unsuccessful, with the occasional victory. So I want to pay particular tribute to our mighty team of solicitors and support staff led by Sinead Lucy. We know just how hard it is to enforce socioeconomic rights for many reasons. There's the lack of legal aid, there's the risk of costs, there's very significant inequality of arms, there can be very extensive delays, then there are procedural rules such as rules on standing, class and multi-party action. But even if all of these could be overcome, and at times they are, there is still great difficulty in enforcing socioeconomic rights in superior courts. Some judges undoubtedly feel that there may be a separation of powers issue and that it is the job of the legislature to divide up the socioeconomic cake. But even when the legislature has enacted legislation providing for rights, for example, in the area of housing, there are still significant hurdles in having these rights enforced in the superior courts. And I'm very struck at how difficult it is to be successful in a claim under the equality legislation once it reaches the superior courts, despite it having a legislative basis and at times being required by the EU. We also have an equality guarantee in our constitution that for the most part, but with some notable recent exceptions, has not been successfully invoked to assist with the assertion of socioeconomic rights. And it has been subordinated to other provisions in the Constitution, especially the right to private property, and the area of disability rights immediately springs to mind. Justice Cameron, on the last time he spoke at a FLAC event, said that there's a slow road to change, but we can see there are some changes afoot. There are separate campaigns now to have the right to housing, the gender grant, and the right to a clean environment enshrined in the Constitution. FLAC has campaigned successfully to have the equality legislation reviewed, and proposals are being considered to look at having a disadvantaged socioeconomic status grant included in the equality legislation and to provide better protection for trans people. We're also pleased that there is a commitment to review the legal aid system, which does not deal and does not have the capacity to deal with socioeconomic rights to any great extent. The former Chief Justice Frank Clark also set up an Access to Justice Committee, and we were delighted to be part of the major conference last month, which considered in detail a number of issues, including awareness and information about rights, the accessibility of the courts, access to legal services for people living in poverty, access to environmental justice, and equal treatment in the court process. We're very pleased that Chief Justice O'Donnell is committed to keeping the work of this committee going and welcome him here today. Other significant developments include that our colleagues in community law and mediation have established a Centre for Environmental Justice. All these initiatives make the topics of what judges can do in relation to social and economic rights so timely and important. Justice Cameron needs no introduction. He's an academic, jurist, author, and recently retired Constitutional Court judge in South Africa. He has developed South African law to truly reflect the fundamental values of the Constitution. His role in securing the inclusion of sexual orientation as a prohibited ground of discrimination in the Bill of Rights as well as his advocacy for persons with HIV and AIDS, has made him a key player in South African and international law. Nelson Mandela described him as one of society's new heroes. On Wednesday, it was announced that he would receive the highest award that South Africa bestows on its citizens who have contributed towards the advancement of democracy and have made a significant impact on improving the lives of South Africans. Before I hand you over to Justice Cameron, can I just say there is a function on the Zoom to ask questions, and we will have a facility later on for questions. Justice Cameron, the floor is yours.
Alish, thank you so much. It's wonderful to be here. I have a live audience in front of me who are hidden away from me by this partial video screen, but I'm absolutely delighted to be back with FLAC. On my right is the new chair of the Free Legal Advice Centre, David Finelli, and I congratulate you on taking on this difficult but very, very important task. I have only one corrective to Alish. She unjustly blamed the Dublin traffic. In fact, we were deposited 15 minutes before 9 o'clock by our taxi driver at Dawson Street, not Dorset Street. So please do not be unjust to the Dublin traffic. I suspect it was all our own fault, but we'll take recourse in blaming the taxi driver. David, can I just pause for a moment to say how profoundly important FLAC's work is, and how profoundly important it is that busy practitioners with heavy burdens like you are doing this work. The commitment to free legal advice, to pro bono work, is elemental to the legal function for many reasons, for prudential reasons, for self-interested reasons, and also for morally convincing reasons. And FLAC does that in Dublin and wider than Dublin. This is my third occasion to be at FLAC. FLAC has a deep place in my heart, and it also has a deep place in the heart of Irish practitioners. Both of our countries suffer from a grave deficiency of legal services. I think South Africa more even than Ireland. One of the benefits that our history has given us in South Africa was the arisal under apartheid of a vigorous public interest law system, often fighting flagship cases, but also providing services like FLAC does to a broad range of people, sometimes with target litigation, sometimes simply on an individual basis. That heritage started in the 1950s with Bram Fischer, who was the leader of the Communist Party, later underground, later imprisoned for life. He was one of South Africa's leading QC barristers, and also by Nelson Mandela and Oliver Tambo, who founded the first black law firm in South Africa, justly famous Mandela and Tambo. And that tradition from the 1950s carried us through the 1960s, Arthur Chaskerson, George Bezos, Sidney Kentridge, other distinguished practitioners, 1970s, and when I very belatedly joined the cadre of public interest law practitioners in South Africa at the Center for Applied Legal Studies at Wits University in Johannesburg, we had a solid tradition of disinterested commitment to making the legal system work for those whom the legal system were oppressing and those who sought entry to it. So Alish, just to say what an absolute joy and an honor it is here, despite your unjust imprecations against the Dublin traffic. I'm really thrilled to be here. And David, it's a great joy to meet you. I think we met in 2016, taking us back to the Easter uprisings. We met then, but what a joy to see your commitment to FLAC in chairing the board on the governance side. I shall make no disparaging comments about Alish's need for governance supervision. Alish, I wish I could see your face because you have the most wonderful Irish smile, if you don't mind me sounding a bit patronizing. So what I'm going to do, it's now 19 minutes past 9. I'm going to try to finish by 9:45 so that we can have a discussion, so that we can have our Zoom participants give questions, and so you can give me questions. Can you hear what we are saying? No, because I'm using these earbuds. So let me start by saying, pausing to reflect on the anguishes and the losses of the last 16 months, 18, 20 months from COVID. It is my country's second mass viral epidemic of loss and grief and death and peril. Our first one, of course, was AIDS, which hit our country at the very time that Mandela was released from prison and that he became president, through many stumbling steps, partly through public interest lawyering. Jeffrey Budlander at the Legal Resources Center, Gilbert Marcus, a practitioner in private practice at Distinguished Silk, who led the demand that President Mbeki's government, despite his AIDS denialism, had to provide antiretroviral treatments, the treatments that I started taking this very week, 24 years ago, 1997, in the first 10 days of November. I knew that they were life-saving. I knew that I had to speak out against President Mbeki's refusal to make them available. The very same questions that we are now facing from vaccine-hesitant people, from vaccine-denying people, from some medical practitioners who are asking absurd and misdirected questions about vaccine efficacy in the United States and South Africa. Those same questions had their parallels with antiretrovirals, and yet they've been proved to be life-saving. South Africa, because of the work of brave activists, brave, angry, principled activists, because of the work of practitioners like David, practitioners like you, practitioners like our friends on the Zoom call, has the world's largest publicly provided antiretroviral treatment program. Brave practitioners, a good constitution, good constitutional rights. Eilish, last night at Trinity College Dublin, you were much in our thoughts, a discussion with Chief Justice Donald O'Donnell, with the constitutional lawyers of TCD, who are very interested in the work that FLAC is doing to try to reform access to social and economic rights through constitutionalizing them, through strengthening the law. So as we reflect on the anguishes of COVID, let us also reflect how it's reminded to us of our mortal frailty as humans, brings us closer again. We could not continue headlong in the way that we were going. We were brought up short, and let us reinvest ourselves in the moral vision of what our law is about. I start off by making a few comments about social and economic rights in South Africa, why they are so important, because the apartheid system was systematized through law, minutely, precisely, grievously, injuriously, cruelly through law, designed to subordinate, humiliate, marginalize, dispossess Black people. And we still face that legacy 27 years into democracy. My researcher at JIX, where I'm now the inspecting judge of prisons, Rebecca Gore, found this anguishing quote from one of our early 20th century authors, Sol Plaatje, who wrote about the morning that he woke up after the 1912 Land Act had dispossessed Black South Africans of most of their land. Awaking, Sol Plaatje wrote, on Friday morning, 20 June 1913, when the act came into effect, a South African native, as he said, Black person, found himself not actually a slave, but a pariah in the land of his own birth. And the point is that the social and economic legacy of apartheid has left many Black people in just the same position, marginalized and pariahs. 3 decades after our democracy, The Economist points out that today, white South Africans, that's me, I'm here, I'm a white South African who benefited from apartheid, we are on average 8 times wealthier than Black South Africans. Let me explore the nuances more. The Economist notes that while the Black elite holds the majority of the wealth in our new elite, the top 10% of South Africans, the gap between the richest, now a non-racial richest, because of Black people's accession to ultra wealth, that gap hasn't narrowed as the decline in racial equality has been driven almost entirely by a surge in the top black incomes. That's not what we want. Our unemployment rate is a staggering 34%. Electricity blackouts are a daily plague to us, and jobs, education, and basic services are the hole in this crisis. The calamity is most anguishingly depicted by the terrible death of a young 5-year-old boy at a school in our northern province, Limpopo, Michael Kumapi. Michael Kumapi's case, bravely taken on by Section 27, Mark Haywood and his colleagues at Section 27, offering the kind of services that FLAC does in Dublin. He drowned in a pit toilet at his school. His parents have found legal recourse. There has been work by public interest lawyers to require the Education Department to end all pit toilets throughout South Africa and schools. That struggle continues. So let's consider the international background, the Universal Declaration of Human Rights, the preamble to the International Covenant on Economic, Social, and Cultural Rights of 1966. Ireland signed that in 1973, ratified it in 1989. We signed and ratified in 2015. The optional protocol to ICESCR, Ireland 2012, ratified. Don't know what action has been taken. Refer to Eilish's introductory remarks. South Africa still pending on the optional protocol. And then, of course, the issue that we were discussing last night and that Eilish mentions, the insufficient grounding, the insufficient vesting in the Constitution and the law of the entitlement to the material conditions of life. That's a beautiful 19th century phrase that those of you who've read Karl Marx will know. It was one of his important insights that we mustn't lose in acknowledging the wrong insights that he had, that the material conditions of life determine your outlook on almost everything else. And the commitment to social and economic rights is a question of simply affording people their basic dignity through materiality, and a reminder that we in this world have enough shelter, we have enough food, we have enough dignity to afford every human being on the planet, all of those things. What we have is a grotesque maldistribution of those. So our Constitution, with a visionary look to the future, the interim Constitution of 1994, which was the transition instrument from the de Klerk apartheid regime. President de Klerk died on Wednesday at the age of 85. I listened this morning to what I thought was a significant and moving final video message that he recorded in his last hours of life, in which for the first time he apologized unequivocally for the injury, the hurt, the degradation that apartheid had inflicted. He took his government, and the debate in our country now is how much recognition and honor he deserves for taking South Africa away from apartheid when we faced the certainty of gross civil war, greater civil war, decline into much more bloodshed. He led us with Nelson Mandela on the ANC side, released after 27 years in prison, into the interim constitution. The final constitution contained what the interim constitution did not contain, which was justicially enforceable, judicially cognizable, and accessible social and economic rights. They are heavily qualified. It's a right of access to housing, a right of access to food and water. Government is under a duty to take reasonable measures through legislation and other measures, reasonable legislation and other measures, to realize these rights progressively within available resources. So there's a heavy padding of protection on government's part, but at the end, it's still possible for judges to scrutinize, and I'm going to tell you in a moment about the most dramatic case, which concerns antiretrovirals, which I've alluded to earlier in my opening. The approach to social and economic rights that doubts their justiciability, doubts their constitutionalization, is, I think, gravely flawed. It relies on conceptual distinctions which are, I think, misdirected and erroneous. All human rights demand both positive and negative action on the part of the state. Even freedom of association requires the state. The right to vote requires state action. Henry Shue indicated convincingly how every single legal right entails a duty on the government to respect, protect, and fulfill it. There is a distinction, but it's a distinction only of degree, not a distinction of concept. Human rights are interconnected and they're mutually supporting. In the Criterion case concerning the right of housing, our court, my colleague Justice Zach Yacoub, said there can be no doubt that human dignity, freedom, and equality, the foundational values of our society, are denied to those who have no food, clothing, or shelter. And therefore, he said, affording social and economic rights to all people enables them to enjoy these other fundamental rights. The right to be free from unfair discrimination, Justice Yacoub said, must be understood in the context of our legacy of deep inequality. Liebenberg and Goldblatt contend that to develop our jurisprudence, to respond to the causes and the manifestations of poverty and inequality, require an interdependent interpretation of all these rights. This is vividly illustrated in one of my favorite cases, which was decided by my colleagues before I joined them, when I went to the court in 2009, the case of Kosa, which was a case of permanent residents who were non-citizens. And there was a regulation that said that they're not entitled to social grants, which had a terrible impact on marginalized, permanently resident non-citizens. And government refusal was overturned by Justice Yvonne Mokoro in a unanimous judgment for the court, recognizing the interconnectedness of all these rights. And in Mhlangu, a very recent decision after I left the court extended these same social security benefits to domestic workers. Why? Because excluding them infringed their rights to equality, non-discrimination on the grounds of race, sex, gender, and class, and also their right to dignity. So we understand all these rights as interconnected. The classic objections to social and economic rights, and these are objections rehearsed in Ireland, concern judicial capacity, judges' professional training. I wasn't trained to make allocational decisions, distributional decisions about a single pot of money or how big the pot should be. The second issue is the question of process. Is the judicial process, which is mostly contestatorial, bipartisan, conflictual, adversarial on two sides, bipartisan, does that best conduce to making that kind of determination? And then, of course, resource limitations. I remember a case that we had, which was also about sanitation, about toilets, Nokotanya, in my first year on the Constitutional Court. I actually suggested to my colleagues, let us go out. It was an informal settlement, some 60 kilometers east of Johannesburg on the East Rand. And my colleagues said, well, we've got all the papers before us. It's not necessary for us to go out and see this. And some of my colleagues rightly pointed out, we grew up with pit latrines. Why do we need to go and see them? I didn't think that was the appropriate attitude, but it did underscore the question whether we had time in our busy schedule to go and see what was happening, to go and talk to the people. Do judges have that kind? Do officials have that kind of time? And then the question of legitimacy, separation of powers. Judges should not venture into certain kinds of terrain. They are lawyers like you, David, which is a rightful source of opprobrium, and they are elite and undemocratically elected. This can, of course, be abated by appropriate levels of what one might call, I'm glad you're smiling, sir, thank you, for me berating David for being a lawyer, by deference or respect, which is a kind of role recognition. When you say, I am a lawyer, I am a judge, this is what I'm best at doing, and this is what I'm not best at doing. So the debate about justiciability has key questions. Are they tailored for judicial enforcement? Should the courts be able to order and supervise the content of the rights? And the Constitutional Court in 1996 very carefully considered these cases. The way in which the negotiators after Mandela's release and de Klerk's concession of the inevitability of majority democracy tailored this was to agree that the Constitutional Assembly would provide a constitutional text, but that it would be subject to certification by the new Constitutional Court against a roll of about a score of principles. And the court found that social and economic rights conformed with all those fundamental constitutional principles. We have been quite hard-headed in South Africa against quite stringent criticism in resisting the idea of the United Nations Committee on Social and Economic Rights, that there's a minimum exigible content to all social and economic rights. We've rather focused on the notion of reasonableness within the South African Constitution, rather than proclaiming that there is a minimum content that is enforceable through all cases. We've said, bring us the cases, let us decide on the basis of the constitutional criterion of reasonableness. The criticism of that is quite trenchant, that the court should clarify and create clear benchmarks, and that relying on this kind of reasonableness standard doesn't do it. Question of remedies is very important. The court, in the case I've mentioned, I'm going to come back to, the Treatment Action Campaign case, led by Zaki Ahmed, who founded the Treatment Action Campaign, took on the drug companies, forced them through moral argument, through campaigning, through international action, through the simple power of his moral position. It is morally unconscionable for you to hold the patents on drugs, many of which were developed by public money through the NIH, the CDC, the universities in America, unconscionable for you to refuse those drugs to 30 or 40 million Africans who would otherwise die of them. He won that argument. He turned to Mbeki and brought Mbeki's denials and brought the case. And the court in TAC said that effective relief is what it required. It has to be effective in order to secure to people the material conditions of life. Declarations of invalidity, interdicts, mandamus, and damages. David, I've got 8 minutes left before. Are you going to be a strict chair? Have you got a gavel there? No gavel. I'm going to finish so that we've got good time for discussion. So the two cases which I would say are the ones, and I mentioned them last night at Trinity College, which really grounded our commitment in a fragile law state in South Africa. As a lawyer, as a former Constitutional Court judge, I have no complacency, no self-congratulation, no self-satisfaction, because there are too many perils facing the rule of law in South Africa. But two cases grounded the rule of law, and both of them involved challenges to powerful presidents. And in both cases, the Constitutional Court stood firm, and in both cases, the presidents in question, two very different presidents, Mbeki under AIDS, Zuma for his appropriation of hundreds of millions of public money for his private homestead at Nkandla. In both cases, the court stood firm and both presidents accepted the court's outcome. Those were the two grounding cases. There have been many rightfully famous cases by the Constitutional Court. And in the Treatment Action Campaign case, it really concerned the provision of antiretroviral treatment to prevent the transmission to mothers, by mothers to their imminently to be born children or their nurtured children, their breastfed children afterwards. But the case really was a very clear sign to the Mbeki government what the court would do if the more general question of availability came. And the court declined to give a structural interdict, but in other cases, we have given a structural interdict. Cases while I was on the court, the notorious, infamous Black Sash trilogy, with the Black Sash, another organization, David, very like FLAC. The Black Sash were started with white women of conscience in the 1950s who stood silently next to the big highways of Johannesburg in protest against the degradation and shame of apartheid oppression. And the Black Sash developed into one of the most reputable, conscience-led organizations providing services, including free legal services, when it was evident that the government grants contract, the biggest public service provision tender in South Africa's democracy, had been fiddled with, grossly fiddled with through corruption at presidential and cabinet level. I did say presidential. This is not being reported. You will not hold me responsible for impugning President Zuma's integrity. At presidential and cabinet level, David, the Black Sash came directly to the Constitutional Court. Black Sash won. The court affirmed its supervisory jurisdiction, appointed the Auditor General plus a panel of experts to evaluate compliance with its order. Not enough. Black Sash 2, the court appoints a referee to make findings on whether Zuma's Minister of Social Services, Madam Batabile Dlamini, had lied to the court. Black Sash 3 grants a personal costs order against her, all in the process of getting to sustain the grants, which were in severe peril of being discontinued entirely through government incompetence, corruption, and ineptitude. So these remedies, structural interdicts, are asserted to be undemocratic. On the contrary, I think they are deeply democratizing. I think it was Chief Justice Donald O'Donnell last night, or perhaps it was Justice Hogan, who said that they embody a conversation between the judiciary and the legislature. I think that's an important insight. I want to tell you about the case that I handed down and the minutes that I allotted to remain to myself, which I also mentioned last night. But it's a disquieting but also enthralling case because it shows the power of legislation, the importance of a capable state, which is now one of the gravest issues in South Africa, the absence of a capable state. 4 years after President Ramaphosa took power, and we hoped that he would rebuild our state, the crumbling edifice of our state capabilities are showing more and more. In 1996, the government enacts a wonderful piece of legislation. It's a Mandela piece of legislation about labor tenants. Labor tenants were Black people, overwhelmingly 99.9% of them, who lived overwhelmingly on white farms. 99% of the farms on which they lived were white farms. They tilled their crops on a small piece of the farm, they had their stock, and they had their homestead, intergenerational homestead. The Labor Tenants Act said, you can keep that ground. That ground can become your piece of land, your piece of Africa. It was a wonderful statute. You apply to the Department of Land Affairs. The farmer is given a chance to contest, to say, well, you've just moved on to the land, your claim is bogus. You can reply. If there's still a dispute, then it goes to the Land Claims Court. Tens of thousands of labor tenants applied within a few years, and it was a real opportunity to afford land title to a significant portion of rural South Africans. What happened? The Land Department botched the entire thing. The claims mounted up, nothing was done. On my last day on the bench in Mwelase, Mr. Mwelase had very tragically died just before judgment was handed down. We gave a structural interdict against the Land Claims Department, appointing a capable officer to oversee the actual implementation. Let me conclude, David. I've got 1 minute left, and then you're going to supervise the questions. I can see there are some very eager questions, and I'm eager for them too. We see ourselves as rightly as a case for scrutiny internationally for constitutionally protected social and economic rights. We've not had a perfect record. I reiterate the humility with which I come to Ireland, the humility with which I sit before you today. Legal scholars put it, and I'm quoting Professor Sandy Liebenberg of Stellenbosch University. I'm on a Stellenbosch University trip here, working for them. She says there is a sense that the transformative potential of these rights have not been fully realized. Very courteous, very gracious understatement by Professor Sandy Liebenberg. This is acute from the point of the realities that most people live in South Africa, which the COVID epidemic has exposed. The complex reasons for this include criminal diversion of resources, especially under Zuma's presidency. Did I say criminal and Zuma in the same sentence, David? I will deny it later. But I repeat, the diversion of resources under his into criminally conspiratorial networks was massive, and we're still struggling with it. And yet there are also structural issues like the vast wealth gap, which white South Africans like myself, newly affluent, newly accumulative Black South Africans cannot escape. The hope is that once we have tackled the issues of criminal capture of the state by criminal syndicates, that we can start to address it, that we can end recalcitrant administration and mismanagement, ensure compliance with court orders, and as before, that our moral claim to lead the world, to provide an example, even in Dublin, with due humility, that claim can be restored. Thank you so much.
Thank you so much, Justice Cameron, for such a really inspiring talk.
Eilish, are you going to?
I'll ask you the one question.
Okay. Don't you think people should see you, David, the new chair of David? Come and look. No, take off your mask. This is to lock David in so that he can't resign after a year. How long are you going to stay on this FLAC's chair?
Oh, just for a short period.
No. We don't accept that. Eilish, how long will we give him? 10 years.
Well, Peter lasted quite a long time. So.
I can't hear you, Eilish.
Peter lasted quite a long time.
So
can you not hear me? No. Okay.
Can you hear Eilish?
No.
We can't hear you, Eilish.
Okay. I'm not sure what.
Better.
It's showing that you're talking.
Eilish, we can hear you. It's just Justice Cameron can't hear you. But the rest of the webinar can hear you, Eilish.
Okay. Well, maybe. Okay. I don't know how to communicate with
Eilish, we're not hearing you. We can see you talking. You're not on mute.
Can Karina be asked to check?
At the outset, but we can't hear you now.
Can Karina be asked to check the audio in Edwin's machine?
Eilish, can you not come down and share?
Okay.
Yeah.
And I suppose in the meantime, Justice Cameron, if there are any questions from
yes, please.
Or audience here, anybody have any questions for you?
And if there's a policeman outside, get Eilish arrested for transgressing the COVID rules. Please.
Sinead Lucy is our manager solicitor, Justice Cameron.
How are you, Sinead?
Amazing presentation.
Thank you.
It's lovely to be here in person. You were talking about the black sash, and I was taken by the idea that this was an organisation that came to the court.
Yeah.
And I suppose in Ireland there are very restrictive rules about who can take a constitutional action, and it has to effectively be an individual who can show that their rights are being breached on a personal basis. And there was a recent case with an environmental NGO that were denied standing to plead under the Constitution effectively on behalf of the public interest. And I wonder if you could just explain how that works, and you said that and what your standing is that would allow an NGO to face in relation to a law-based constitutional.
Thank you very much. Sinead, is it? Thank you very much for that question. Again, paradoxically, our rules on standing are a consequence of restrictive application of standing under apartheid, where it was used before the apartheid government, for example, allowed black trade unions. Until 1979, it was a criminal offense for black people to join a trade union or to form a trade union. Amazing. There were works committees. I'm sure there's a comparable history in 19th century England and Ireland. And those works committees were held by the courts not to have standing, to act on behalf of all the workers, which looking back seems almost inconceivable. But that was what the apartheid courts held. So Section 38 of our Bill of Rights is extremely generous. It says that anyone may act in the public interest, may act on behalf of someone else who cannot act, may act on their own behalf, but including a wider group of people. And the interesting thing, which is an important lesson, I think, for Ireland, the lawyer's argument, the black letter lawyer's argument against wide-standing rules is the meddlesome outsider, the busybody. It hasn't happened. The black side, you recognize a busybody. There have been very, very rare cases where we've said you're a busybody, you're not going to get amicus standing. But mostly the South African courts, especially the Constitutional Court, welcomes people, welcomes both sides of the debate. We don't only have what are called progressive NGOs, we also have NGOs who take the opposite line. They're also welcomed. So the more people that participate in a debate about the meaning of rights, about the entitlement to effective orders, the more legitimate they become. And the same too with standing. So our Section 38 is very wide. The Black Sash could have shown a narrower interest because many of its members, many of the people it served were going to suffer if the social grant system stopped operating because the minister heedlessly was not going to allow the contract to go out to tender. She wanted the old corrupt tender to be compulsorily or mandatorily continued, and we stopped that. But the Black Sash could have shown that it had members, so it could have shown a narrow interest, but it wasn't even queried. It was quite clear that this is an organization with a long history of disinterested solicitude for the dignity and rights of a wide range of people. And I commend that wider standing approach to lawyers in Ireland. Thank you.
Thank you very much, Justice Cameron. Any further questions for Justice Cameron from the audience? Justice Cameron, I suppose I have one question for you. We have had a constitutional discussion about socio-economic rights in Ireland in recent years. Our constitutional convention considered the issue, recommended by a resounding majority that socio-economic rights should be given protection under the Constitution. What words of reassurance would you have for the political actors in considering those recommendations that were made some years ago in terms of the potential implications of incorporation into the Constitution?
Words of reassurance and exhortation, David, because the question at the back of all the other questions is the extent of the embrace of the legal system. And what kinds of human needs and entitlements do you permit to be afforded legal recognition? And to afford social and economic rights legal recognition, exigible, enforceable legal recognition, is a reinforcement of the legal system itself. It's an enhancement. And it's the same debate as is held in Australia. It's a very closely analogous debate. Should there be a Bill of Rights in Australia? Well, we have the common law. It's the same debate, I suppose, as about the repeal of the Human Rights Act across the Irish Sea. And what affording exigibility to a wide range of people does is to involve them in the legal system, to involve them in the assertion of their own dignity as citizens in the broad sense, not passport ID number citizen, but moral citizens of the society. So I think it is a reassurance. I think it's a pinched approach which depletes the legal system of the legitimacy that is that it can gain from going wider. Thank you very much.
Further final questions? We've got Eilish back there, yes.
Eilish, are you back? Can we hear you? I promise you I've not muted you, Eilish.
Eilish, it doesn't appear to be there.
I see there are two
No, I
questions
am
on
here.
the Q&A, David. Let's just look. Yes. There's Emma Cassidy. Emma Cassidy asks, are there any interesting trends that are emerging in target public interest litigation? What advice have you for the next generation? Hello.
Can I just do something?
Yes,
that might help
please.
you?
We want to hear Eilish.
Okay, so we think that's one of the battery.
Oh, it's battery.
Okay. So
Did you do that on purpose? To mute Eilish? And then this is Emma from Pills in Belfast. Lovely to hear from you, Emma. What is happening is that a lot in South Africa has been on schools and environmental, increasingly, to answer Emma's question, education and environmental. Are you managing there?
red is your color, okay?
Oh, lovely.
So
Excellent.
do you have to take the AirPods out?
Okay, yes. But can everyone else hear?
Yeah.
Okay, great. Thank you so much.
You're welcome.
Eilish, let's take Otto Crow's question, and then I think that's the last question, David. You mentioned being recently involved in inspecting South African prisons. I met some South African NGOs when we traveled a few years ago. Many mentioned that the government was very reluctant to offer internal observation of the activities in prison. What role were you permitted access, and how did you find conditions? Excuse me. It's a very good question. Thank you for that, Ola. What happened also in that era of wonderful Mandela legislation, 1994 to 1999, is that they abolished the previous Prisons Act, the Prisons Act of 1959. And instead we had the Correctional Services Act, which is now still the statute governing prisons. And it changed from being punitive to being focused on education, rehabilitation, and reintegration. Well, like much of South Africa's visionary promises to itself, the reality is harshly different. One of the things the statute did was to create an inspecting judge of prisons. Since my retirement, I've become the inspecting judge of prisons. In Ireland, I asked the Chief Justice this last night, you have a Chief Inspector of Prisons, I believe. Your previous Inspector of Prisons, who sadly has recently passed away, did a wonderful job, the Chief Justice. I'm talking a bit out of turn here. He said that he had the opportunity to read many of his reports in recent litigation. What wonderful, deep going and insightful reports they were. And the same in England and Wales, there's an inspector, not an inspecting judge. So I have ample powers to visit any prison. We've got prison monitors at every prison who are there between 3 and 5 days a week on a part-time basis. There are many questions. Foucault said it doesn't matter whether you give prisoners a chocolate at Christmas or an Easter egg in April. So there are lesser evil questions about whether prisons can be reformed, whether a watchdog has an ultimately beneficial role. I believe that we are playing a beneficial role. We have access to all prisons. We are tackling difficult issues right at the moment, like solitary confinement, which is prohibited under the new statute, but is now called segregation. We're tackling that head on. Many other issues, overcrowding being one of the gravest issues. And I think over-criminalization, we can hear you now, Eilish. Over-criminalization, let me just say this very quickly. We fell victim to the war on drugs that Richard Milhouse Nixon announced vaingloriously and desperately wrongly in June 1971, the 50th anniversary of the war on drugs. Wrong. Drugs, all drug crimes. It's a public health issue. Portugal has done it. Other countries have done it. with benefit to the public health. I'm advocating that we do the same. I have the support of our former president, Kalema Moplante. And then minimum sentences. We took them from, was it Jack Straw, the Home Secretary in England, 1998, from Minnesota in 1998. Terrible mistake. I'm campaigning against them as well. We've got too many people in prison. Long answer, Eilish, you've got 1 minute to end. I've taken up all your ending time. It's very rude.
Just wanted to thank you so much, Justice Cameron, for such an inspiring and thought-provoking talk. I thought you would lift the mood, and I think you really have. Apologies for all the technical difficulties at the beginning and throughout it. And can I just thank your minders, Darren and Rebecca, who've been an absolute pleasure to deal with, and to thank Tom at IT, and a very sincere thanks to all the FLAC team who made tremendous efforts in very short time to make this happen. Ingrid, Danielle, Stephanie, Alessia, Karina, Liz, and Caroline. And thank you very much. Thank you.